Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Get it off of me. Get it off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?
Just in my rehearsal room. Hold on, hold on, hold on, hold on, hold on, hold on, hold on. Everybody hold on. Hold on, hold on, hold on, hold on. Robert is coming home. He's coming home. Hold on, everybody hold on. Robert is coming again. He's coming home. Hold on, everybody hold on. No matter what they say, no matter what they do, no matter how it seems, God's got the final say. It doesn't matter how long it may seem, the end is what matters. But God's got the final say. So hold on, everybody, hold on, hold on, hold on, hold on, oh, hold on, hold on, for Robert, hold on. The enemies may hate, they can tell all lies. No matter how long, the truth will prevail. They can rise up against all the fans that stand up for him. The end will justify, for God has the final say. Oh, no, 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 yo. Hold on. Hold on, hold on, hold on. Robert is coming home. He's coming back, so hold on. All fans, hold on. Hold on, hold on, hold on, hold on. Hold on, hold on, hold on, hold on. Help is on its way. Heaven is down here. Hold on, all fans, hold on. God is here, taking it over. Hold on, everybody, hold on, hold on, hold on, hold on.
Hey guys, it's me, Sylvia. I'm back. I guess we're going to be waiting for the other part of Jennifer's motion, but we're going to go ahead and read the first part first, and this is regarding the acquittal. We're going to have our wonderful Miss. She said everybody. I just Rhoda's gonna read it for us, and Mel's coming along as well. You just threw me off by saying everybody. All right, guys, I'm gonna bring it up. Yeah, I was trying to hope for Mel to come in so I could see when she come in. But go ahead on, Rhoda, and we can begin. I just want to make sure I'm able to see Mel
Okay.
when she gets in here.
Okay.
But I'll show it up in a minute as soon as Mel comes up.
We
Because when
start
I put it up, I can't see.
we starting with number one. The government failed to approve that one.
You can start from the beginning.
Okay. That's that we got paged all the content. So yeah, this is the beginning. Okay.
Yeah.
Let me know when you're ready.
I'm ready.
All righty. 1. The government failed to prove defendant guilty of the offense of racketeering. Count 1. A. Where there was no common purpose to carry out a fraudulent course of conduct, the government did not establish an enterprise. The government concedes that its evidence did not prove that the defendant's employees shared a common purpose of criminality, but contends that to demonstrate a RICO enterprise, it was only required to show that the defendant's employees shared a common purpose to promote his music and meet his personal needs. Despite authority to the contrary, the government insists that to prove a RICO enterprise, the members of the enterprise need not have a connection to any unlawful conduct. According to the government, so long as the persons associated in fact share a common purpose, a RICO enterprise may exist, even if those persons do not have a common understanding that the purpose of the enterprise is to carry out illegal or fraudulent conduct. Under the government's theory, an enterprise exists when any individual is engaged in a pattern of unlawful conduct, racketeering activities, and merely uses his employees to unwittingly facilitate that conduct. The government's argument is belied by the law and common sense. At the outset, the government is unable to provide a single case that supports its expansive view of a RICO enterprise, nor is it able to identify any factually similar authority. Instead, the government represents the refrain that an enterprise may constitute a legal entity. But this point is not in dispute. An enterprise can be either a formal or informal organization that conducts purely illegal activity or conducts largely legal activity. Any union or group of individuals associated, in fact, can constitute an enterprise. However, to sustain a charge of RICO, the members of the enterprise must share a purpose of carrying out some course of unlawful conduct. If this was not the case, a RICO enterprise could be established by one bad actor using his employees, his neighbors, or even his friends to unwittingly facilitate that misconduct. The framers of the RICO statute did not intend this absurd result, and courts have not hesitated to reject this expansive view of a RICO enterprise. Strangely, the government cites Mouse versus BMO Harris Bank to support its argument, but Mouse strongly supports defendant's position. There, the plaintiff brought a putative class action against First Premier Bank, alleging RICO violations. Specifically, the plaintiff charged that FPB, a former legal entity, belonged to the Automated Clearinghouse Network, a payment processing system that processed unlawful ACH transactions on behalf of payday lenders. The plaintiff argued inter alia that the ACH network constituted an enterprise consisting of originators, various depository financial institutions that receive ACH transactions instructions, ACH operators, and third-party service providers, all of which share the common lawful purpose of facilitating batch processing of electronic payments for and between participating depository financial institutions. The court concluded that the ACH network described by the plaintiff did not constitute an enterprise for RICO purposes. The court held that to satisfy the first prong of the Boyle test, the participants in an association, in fact, enterprise, must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. The court dismissed plaintiff's claim, finding that the plaintiff's failure to plead an association, in fact, enterprise that shared a wrongful intent to violate RICO was fatal to the claim. Affirming dismissal of association, in fact, RICO claim, where the amended complaint admitted that certain participants in the purported enterprise were not aware of deceptive practices at issue. The Mouse Court expressly rejected the plaintiff's enterprise theory, finding it implausible that all of the institutions that allegedly made up the enterprise possess the unlawful intent required to transform that cooperative into an association, in fact, enterprise for RICO purposes. Dismissing RICO claims that allege that defendants used the Mortgage Electronic Registration System, MERS, to conceal unlawful mortgage transfers because plaintiffs failed to show coordinated activity to jointly achieve a common fraudulent purpose, emphasis in the original. Critically, the plaintiff and Moss argued that the defendant's bank shared a common purpose of the ACH network and used the ACH network to originate lawful and legitimate transactions, but also used its role within the ACH network to participate in the collection of unlawful debts. Relying on Antiel Supra, the Mouse Court observed that at best, the defendant used a legitimate network to advance its own illegitimate business interests, and that the alleged illicit ACH transactions did not render the ACH network a RICO enterprise, absent a common purpose among other network participants to violate RICO ID. The Mouse Court's logic applies with full force here. The government's evidence showed that the defendants so-called inner circle, more aptly described as his employees, worked to promote defendant's music and brand, a legitimate enterprise. At best, the government's evidence showed that the defendants used his role within his music-driven collective to participate in private sexual misconduct. As in Moss, defendant's use of his otherwise legitimate music business to advance his allegedly illegitimate sexual needs does not render defendant's business organization a RICO enterprise, absent a common purpose among his employees to violate RICO. Thus, the government's RICO enterprise theory fails. Courts have rejected the government's expansive theory of a RICO enterprise because it would extend RICO liability to a vast marketplace based on one bad actor's mere association with the other members of that collective. By way of example, under the government's theory, both Fox News and NBC News constitute RICO enterprises because of the bad conduct of Roger Ailes and Matt Lauer, respectively. Roger Ailes, the former CEO of Fox News, allegedly sexually harassed, inappropriately touched, and exposed himself to women, some as young as 16 years old, while working at Fox News. Under the government's expansive interpretation of enterprise, Fox News and its employees who worked for Ailes, his assistants, his secretaries, his drivers, etc., constitute an enterprise for RICO purposes because they presumably shared a common purpose to promote Fox News and meet the needs of its CEO. By the government's logic, if Ailes' assistant carried out the tasks, such as scheduling appointments, arranging transportation, or making lunch reservations for Ailes and women he harassed or assaulted, those assistants constitute members of a RICO enterprise, irrespective of their not knowing involvement in Ailes' unlawful conduct. The same can be said for Matt Lauer, former NBC News anchor, who was accused of repeatedly harassing and assaulting his female colleagues, sometimes while traveling for work. Consistent with the government's theory, any of Matt Lauer's assistants, handlers, drivers will qualify as members of an enterprise for RICO purposes if in the course of their duties, they facilitated Lauer's illegal sexual conduct, even unwittingly. Of course, the government has shown no willingness to use its aggressive RICO theory against powerful white men, but the fact remains that if its RICO enterprise theory in this case is sanctioned, the government will have virtually unlimited power to charge a single bad actor with RICO. In sum, the government concedes that it failed to establish an enterprise when it offered no evidence that defendants, various employees over the course of 2 decades engaged in coordinated activity to jointly achieve a common fraudulent purpose. As summarized by the government in its opposition papers, the evidence at trial showed only that the defendants' employees generally engaged in a variety of tasks that supported defendants' relationships, not that they performed activities with the purpose of supporting illegal conduct. Because the government failed to prove that the members of defendants' so-called inner circle acted jointly to achieve a common fraudulent or illegal scheme, this court must acquit defendant of RICO. B, the government's evidence of an enterprise distinct from the defendant was wanting. The government insists that its proof satisfied the person enterprise rule because the enterprise consisted of more than the defendant. The government's summary conclusions are not backed up by this evidence. The government argues that the purpose of the enterprise was to promote defendant, his music, and his brand, and to ensure that his needs were met. Illogically, the government argues that the enterprise was distinct from the defendant, but fails to identify evidence to support this contention. Frankly, the government seems to concede that the defendant is the enterprise, and that the enterprise simply does not exist without him, which explains why it failed to charge even one other person in connection with the alleged vast RICO enterprise. The government offers only a feeble response to defendant's discreteness challenge, citing no authority to support its contention or distinguishing the holdings of Riverwoods. That's case. By alleging a RICO enterprise that consists of defendant and his own employees, agents carrying on his affairs, namely promoting his brand, his music, and even facilitating his sexual needs, the government fails to satisfy the distinctness requirement. Put differently, because the government alleged that defendant's employees associated together for no purpose other than to carry out defendant's need, including his sexual activity, the employees did not form an enterprise distinct from the defendant. Defendant and the alleged enterprise were one and the same. B, the government failed to prove that the so-called enterprise's activities affected interstate commerce. The government's interstate commerce argument hinges on its theory that the purpose of the RICO enterprise was to promote defendant's music and brand. As argued supra, this RICO enterprise theory fails because there is simply no nexus between this collective of individuals who work to promote defendant's music in a course of fraudulent conduct or the racketeering activity in which the defendant is alleged to have engaged. If defendant's legitimate music collective constituted an enterprise for RICO purposes, the government's argument would be well taken. But for the reasons identified supra, the government cannot prove a RICO enterprise based on individuals associated in fact for the purpose of promoting defendant's music. C, the government's proof did not establish a pattern of racketeering. 1, production of sexually explicit materials, Racketeering Acts 2, 7, and 10. The government charged defendant with 3 violations: for allegedly videotaping a consensual sex act with the 17-year-old Stephanie, videotaping a sex act with 17-year-old Jane in the state of California, where the age of consent is 18, and 3, videotaping a sex act with Geronda in Illinois before she turned 18 years of age. The government argues that it provided sufficient proof of these violations because defendant used the minors to take part in sexually explicit conduct for the purpose of producing a visual depiction of that conduct. The government argues that pursuant to authority in this circuit and others, proof that defendant photographed or videotaped the minor without more is sufficient evidence of a violation because videotaping the minor alone constitutes use of the minor. Although it is true that several circuits, including the Second Circuit, have held that the use element set forth in is satisfied when the defendant intentionally films a minor's sexually explicit conduct, defendant maintains that use requires more than a minor appearing in a photograph or video. To reach a different conclusion would render the remaining terms in the statute, persuade, induce, entice, coerce, superfluous. It is a cardinal principle of statutory construction that a statute ought, upon a whole, to be construed that if it can be prevented, no clause, sentence, or word shall be superfluous or insignificant. If, as the government argues, a 2251A violation is established by nothing more than proving that a defendant photographed or videotaped the minor in sexually explicit conduct, the terms persuaded, induced, enticed, or coerced, or are entirely unnecessary. To accept the Saris course interpretation of the word use is to render the remainder of the sentence meaningless in direct contradiction to principles of statutory construction. To read the statute where each word has significance requires a court to define use as something more than the act of filming, photographing the minor. Defendant acknowledges the authority to the contrary, but maintains that the law is contrary to the intent of the framers of the statute. Number 2, Mann Act violation, exposure to STDs. A, Racketeering Acts 8A and 12A, intent. In keeping with its dictamus approach to statutory interpretation, the government argues that even though it charged Mann Act violations based on defendants' violation of state public safety laws prohibiting knowing exposure to STDs, the government denies that it must prove that defendant arranged the travel of Jane and Faith with the intent to violate those laws. With no authority, the government argues that it was sufficient to show only that one of defendant's motivations in arranging for Jane and Faith to travel to meet him during his music tours was to have sex with them, not to violate the charged offenses. The government simply ignores its obligation to prove a nexus between the transportation and the alleged illegal conduct. This is a recurring pattern in the government's prosecution of this case. The illegal sexual activity that the government charged are specific offenses pursuant to the California and New York public health codes. The record is devoid of any evidence that a significant or motivating purpose in arranging for Jane and Faith's travel was to expose them to an STD. The government devotes 6 pages of its discussion to reviewing the copious amount of testimony it presented in connection with defendants' alleged conduct of having unprotected sex with Jane and Faith, who never contracted genital herpes in any event. But none of this testimony demonstrate that defendants' actions of arranging for Jane and Faith to travel to meet him was motivated by an intent to expose Jane and Faith to STDs. The government continues to ignore the salient arguments here, namely that it failed to show that the defendant was motivated to have Jane and Faith travel to meet him so that he could expose them to an STD rather than to simply have sex with them. B, Racketeering Acts 8B and 12B, persuasion, inducement, enticement, or coercion. The government continues to push a narrative it knows to be false, namely that defendant induced, enticed, coerced, or even persuaded Jane or Faith to travel to meet him in California and New York, respectively, to engage in illegal sexual conduct. The undisputed evidence shows nothing of the sort. In both scenarios, defendant asked Jane and Faith to meet him at his concert, and they accepted. Both young women were eager to meet the defendant and did so with a clear understanding that it would likely involve sex. As set forth in detail in defendant's opening papers, Jane's contemporaneous text messages with her mother show that Jane's mother engineered Jane's relationship with defendant. The text messages reflect that Jane and her mother communicated incessantly about how Jane could entice defendant into a relationship that Jane's mother hoped would catapult her into stardom. Prior to traveling to California, Jane's mother demanded that she continue to text defendant. You better be texting him so you will stay on his mind. Jane dutifully reported to her mother that she had spoken to defendant about flying to California to meet him, and that defendant told her that she could meet him whenever I tell him, tomorrow if I choose. As the government concedes, defendant had no idea that Jane was 17 years old, since Jane and her parents actively misled defendant about her age. During her trip to California with defendant, Jane and her mother were in constant communication. Jane never once complained that she had been enticed on false pretenses or that she felt misled. Quite the opposite. The text messages reflect that Jane was having the time of her life and thrilled to be romantically connected to the defendant. Similarly, Faith's testimony on this issue shows that the defendant asked her if she wanted to hang out. Faith agreed, and defendant merely paid for her travel. The record is devoid of any evidence of persuasion, enticement, or inducement on the part of the defendant. Faith may have decided to travel and hang out with the defendant because she sought to be near a celebrity. But this motivation on her part had nothing to do with defendant's conduct. Defendant's status as a famous R&B singer does not amount to enticement, notwithstanding the government's argument to the contrary. The government suggests that defendant's act of arranging for Jane's travel is sufficient to demonstrate that he induced her to travel to California because he caused her to travel. The law says otherwise. The Second Circuit has made clear that the terms persuade, induce, entice, and coerce are words of common usage that have plain, ordinary meanings. The court distinguishes this conduct from merely asking, which is not sufficient to demonstrate criminality. Recognizing that there might be some uncertainty as to the precise demarcation between persuading, which is criminalized, and asking, which is not. Keeping with this pattern of rewriting statutes, the government suggests that it need only prove that defendant caused Jane and Faith to travel to meet him to sustain the charge. The government relies on a 1959 case from the Fourth Circuit that interpreted the now defunct version of the Mann Act that was historically used by the government to persecute Black men who had relationships with white women. The current iteration of the Mann Act does not contain the caused language like the 1958 version did. Moreover, as discussed in detail, infra harms actually stands for proposition that the government must provide specific proof of persuasion to sustain its burden. The government's reliance on harms is misplaced. Contrary to the government's claim, it was required to prove beyond a reasonable doubt that defendants persuaded, induced, or coerced Jane to travel to California, not merely asked. The government's evidence was wanting. The court must acquit the defendant of this Mann Act violation and all others. C. New York Penal Law 120.20. The government charged defendant with the violation of the Mann Act as to Faith based on the theory that he committed the offense of reckless endangerment when he had unprotected sex with her in New York without disclosing he suffered from genital herpes. The government again rehashes its excessive herpes testimony, insisting that a reasonable jury could easily conclude from the trial evidence that defendant created a substantial risk of physical injury when he had unprotected sex with Faith. Taking the government's evidence in its best light, it failed to prove that when defendant had sex with Faith, he created a substantial risk of physical injury. First, because Faith was not afflicted with herpes and did not testify that she observed any evidence that defendant had an active infection. The only reasonable inference to draw is that defendant did not have any type of outbreak when he and Faith had sex in New York. The government insists that this fact is irrelevant, but whether the defendant was engaging in unprotected sex while suffering from an active infection or during a period when he had no symptoms is entirely relevant to his state of mind and relevant to the issue of whether he acted recklessly. Surely, the government would argue that it is more reckless and the risk of harm is more substantial if defendant had unprotected sex with Faith during an active outbreak. Thus, the question of whether Faith was infected with herpes in New York is relevant to defendant's state of mind and whether he acted with the requisite intent. Furthermore, the government's evidence simply did not prove that there was a substantial risk of death or serious physical injury. As argued at great length in defendant's opening memorandum of law, the government's herpes expert testified at length about rare complication of herpes that arguably would qualify as serious physical injury. But unless those risks were substantial, the government cannot meet its burden. Since the risk of serious physical injury associated with herpes is low rather than substantial risk, the government failed to prove reckless endangerment. D. New York Public Health Law 2307. For the reasons fleshed out in defendant's opening memorandum, New York Public Health Law 2307 is unconstitutional. Inter alia. It fails to define infected. While the government in this court assumes that infected means carrying the virus rather than having the ability to transmit it, no authority supports this interpretation. Such an interpretation will lead to arbitrary and discriminatory enforcement, as it did in this case. As a reminder, the government can point to no case in which an individual was charged with the violation of this public health law, where the accused did not even transmit a disease to the alleged victim. C. Violation of California Health Safety Code 12290. The government argues that it was permitted to charge defendant with a repealed statute and rewrite it so that it would pass constitutional muster. Unsurprisingly, the government has no authority to support its view that it can take up the role of the California's legislature. For unknown reasons, the government relies on a 1978 case out of the Third Circuit that fails to support its claim that it has the authority to charge and prosecute repeal statutes and to further step into the shoes of lawmakers and rewrite statutes to its liking. The government also inexplicably cites which considered whether a certain charge violated the ex post facto clause since the alleged conduct occurred prior to the enactment of the statute. The issue raised here is different. The question before this court is whether the government was permitted to charge a version of the statute that did not exist at the time of the prosecution. The United States Supreme Court answers that question in the negative. The government points this court to no competent authority, demonstrating that the antiquated version of the California public health law may be kept alive. As such, the government had no authority to charge and prosecute defendant under a repealed and inoperative statute. 3. Racketeering Act 5, Mann Act violation, Geronda. The government expresses some confusion over defendant's interstate commerce argument. To be clear, defendant did expressly argue that purely intrastate use of cell phones does not constitute use of a facility of interstate commerce. Defendant did more than vaguely suggest this argument, as the government contends in footnote 28. Defendant cited authorities to support the proposition, namely, and further acknowledged a Second Circuit case that arguably conflicts with Gonzalez. The issue is properly preserved and presented to this court. If the court would like additional briefing on this issue or the many others raised in Defendant's Rule 29 motion, it certainly has the authority to order it. If it wasn't clear enough, Defendant argued in the alternative that even if its intrastate cell phone use does satisfy the Commerce Clause requirement in some circumstances, it did not do so here. The government showed only that Geronda and the defendant sometimes communicated by cell phone. The date and nature of those communications are unknown. The government asked the jury to assume that defendant induced, persuaded, enticed, or coerced Geronda to engage in prohibited sexual activity during their cell phone communications without proving the communications or even eliciting testimony from Geronda about what the communications reflected. The government routinely attempts to avoid nexus requirement. It must be reminded that the government was required to show that defendant used a cell phone to commit the specific prohibited act, namely to induce, persuade, or coerce Geronda to engage in unlawful sexual behavior. The government cannot satisfy that burden by generally showing that the defendant and Geronda sometimes communicated by cell phone and that on some unrelated occasion they engaged in unlawful sexual activity. The language used in those communications, to the extent they existed, is important for determining whether the defendant induced, persuaded, enticed, or coerced, or merely asked Geronda, which would be insufficient to demonstrate criminality. While the government cites some authority to support its contention that interstate commerce can be established by intrastate cell phone use, none of the cases cited by the government condone asking a jury to assume the content of those communications as the government did here. In U.S. versus Vickers, the defendant was charged with the 2242A violation, not a violation under 2242B. The Vickers court was never faced with the question of whether the government can satisfy its burden of proof without ever introducing the communication that it claims constituted persuasion, inducement, or coercion, nor was the Vickers court faced with an interstate commerce question. Acknowledging the problems with its proof, the government relies on Bloomfield versus USA, a 60-year-old case out of the Eighth Circuit that interpreted the repealed and outdated Mann Act statute. That aside, Bloomfield involved a defendant arranging for a prostitute, Ms. Tollefson, to cross state lines for the purposes of prostitution, where the evidence showed that the defendant telephoned Ms. Tollefson for the precise purpose of hiring her to cross state lines and engage in prostitution in exchange for money. It is no surprise that a jury concluded that the defendant used the telephone to induce Ms. Tollefson across state lines for prostitution. In contrast here, Geronda testified that she had a sexual relationship with the defendant that was carried out entirely in the state of Illinois. She did not describe herself as a prostitute and admitted that she went to parties at the defendant's home, hung out there for extended periods of time, and even went to the defendant's home when he was not there. Although the government offered general evidence through Geronda's testimony that Geronda and the defendant sometimes communicated by cell phone, it simply failed to prove that the defendant used the phone, persuade, induce, or coerce Geronda into unlawful sexual activity. The government's proofs were insufficient as to Racketeering Act number 5. Number 4, Racketeering Act 9, Jane. In response to the defendant's claim that the government failed to prove that defendant took any action to induce, persuade, entice, or coerce Jane to travel to California between September and October 2015, the government again relies on pitiful 1959 Fourth Circuit case, Harm versus USA Sopra, claiming that inducement simply means to cause. Harms does not stand for the proposition the government contends. Indeed, harms supports defendant argument. In harms, the question at issue was whether the government proved that the defendant directed or knew that the victim would travel by common carrier. The victim had previously worked for the defendant as a prostitute, and after having a conversation with the defendant, she traveled across state lines by interstate airline carrier, and thereafter engaged in acts of prostitution in establishments maintained by the defendant. Evidence that the defendant had induced the victim to travel for the purpose of prostitution was ample. However, the defendant argued that the government's evidence was insufficient to show that the defendant either directed or knew that the victim would travel by common carrier. The Fourth Circuit concluded that it was not essential for the government to show that the defendant directed or knew that the victim would travel by interstate carrier. The court reasoned that because the government proved inducement, the fact of the resultant trip by interstate carrier was sufficient to justify conviction under 2422. The court held it was not necessary for the government to go further in an attempt to show that harms the defendant knowingly caused the victim to travel by common carrier, either by direction or knowledge that the victim, Bruno, would use that mode of transportation. Cause is a word of very broad import, and its meaning is generally known. The knowing persuasion to make the interstate trip, of course, must be shown with some degree of particularity. But once the knowing persuasion has been shown, if the trip by interstate carrier follows, the offense is complete. Contrary to the government's argument, harms does not hold that inducement or persuasion means cause. Quite the contrary. Harms makes clear the government must show persuasion to make the trip with some degree of particularity. The court merely noted that once the government proves persuasion, it is not required to separately show that the defendant knew how the victim would travel across state lines. Here, the government did not demonstrate persuasion, inducement, or coercion. Jane offered no testimony to suggest that she was coerced or enticed into traveling to California in fall 2015. The record shows that Jane was desperate to return to the defendant after he sent her home and was eager to travel with him. Jane's testimony about defendant's rules and sexual proclivities during this time period are not sufficient evidence of coercion to travel, even if Jane now believes with the benefit of hindsight that defendant's conduct was controlling. 5. Forced labor, racketeering acts. The government contends that Geronda's act of giving oral sex to the defendant on one occasion in January 2010 was an act of forced labor. As set forth in detail in defendant's opening memorandum of law, the forced labor statute was not intended to punish isolated acts of abuse. But even if it was, the government did not show a nexus between the physical assault and the sexual act. Taken in its best light, the government offered evidence that on one occasion, Geronda threatened to punish Geronda for breaking into his home and physically assaulted her on a separate occasion because she failed to show him proper respect. Geronda did not testify that the physical assault was intended to force her to perform oral sex on the defendant. This evidence falls painfully short of proof of the offense of forced labor. Geronda could have testified that she gave defendants oral sex because he threatened her or because she feared he might assault her. But those words never came out of her mouth. Random act of violence plus a sex act does not equate to forced labor. The government should not be permitted to warp statutes beyond recognition simply because it seeks to punish isolated acts of abuse that occurred decades ago. Similarly, the government did not prove that Jane engaged in group sex acts because she was forced to. Jane's hindsight testimony that she did not want to participate in that conduct is not proof that she was forced to. The government cannot establish the offense of forced labor by simply showing that defendant and Jane had a sexual relationship that some might consider abusive. The government was required to establish a causal link between the group sex act and threats of physical violence. It failed to do so. Finally, no rational jury could conclude, based on the evidence adduced at trial, that defendant knowingly obtained or agreed to obtain any labor or services from Faith on January 13, 2018. As discussed, the forced labor statute was not intended to reach isolated conduct like that described by Faith. Faith never testified that she felt forced to perform oral sex on the defendant. Not wanting to have oral sex is not the same as being forced to engage in it. Furthermore, Faith admitted proudly that she was not a victim and made a choice to be involved with the defendant. When she was displeased with the relationship, she walked away. The government's infantilization of Faith in quest to redefine her experience as forced labor is offensive to women who actually live in conditions of servitude. The harm that forced the labor statute was designed to address. For the foregoing reasons, this court must acquit the defendant of all forced labor conviction. Conclusion. For the foregoing reasons, this court should enter in order acquitting defendant of all offenses. Respectfully submitted, Jennifer Bone Jean. Woo.
Thank you so much. All right, Mel, next, your turn.
All right, what you got me reading? Which one?
Both of them.
All right, well, I'm gonna start with page 1, or the one pager there.
What's the number?
It's the first one. It's Kelly's statement.
281 or 280?
283.
281-1? Okay.
283-1.
Okay, sorry.
Yeah, no worries. Let me know when you're ready for me.
I'm ready. I'll just bring it up. I'm ready.
Okay. So this appears to be a declaration from Robert S. Kelly, and looks like a 12 sentence statement. Declaration of Robert S. Kelly. Number 1, I am the defendant in the above caption matter. I'm making this declaration to provide additional facts about my participation in the jury selection process at my trial. I did not participate in jury selection in any meaningful way. I was not asked by my attorneys to offer any input about what types of questions should be included in the jury questionnaires that were submitted to potential jurors. I also did not review any of the completed jury questionnaires with my attorneys prior to trial. Because of my limited literacy, I relied on my attorneys to review the questionnaires with me prior to trial, but that did not happen. Number 6, during the jury selection process, I did not participate in any sidebars related to questioning of jurors, and I was not asked for my opinions about potential jurors. My lawyers picked my jury. I did not. At certain points during jury trial, at certain points during jury selection, I did hear that some jurors may have seen the Surviving R. Kelly docuseries, and that concerned me greatly. I raised my concerns with my attorneys, but they shooed me off. I was nothing more than a bystander in the process. I did not know that some of my jurors had seen the docuseries Surviving R. Kelly. I also did not know that some of my jurors were familiar with prior allegations against me, including my prior criminal proceedings in Illinois. Had I known that information, I would have challenged those jurors as unqualified. I also would have told my attorneys to strike the jurors. I did not consent to any jurors sitting on my jury who had knowledge and familiarity with the intimate details of my case or who had watched the Surviving R. Kelly docuseries. There was no strategy involved in choosing the jurors that sat on my jury, as far as I could tell. At least, there was no trial strategy that involved my input. Signed today, April 4, 22, Robert S. Kelly.
Bam.
Bam, bam.
All right now. Let's continue to the next one.
Okay, so this is the defendant Robert Kelly's reply to the government's memorandum of law in opposition to his motion for a new trial. Defendant was denied effective assistance of counsel where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom had watched the inflammatory docuseries Surviving R. Kelly or were familiar with prior accusations of sexual abuse of minors against defendant. Counsel's objectivity, unreasonable performance during voir dire resulted in the impaneling of a jury that was neither fair nor impartial, in violation of defendant's due process guarantees. The government defends trial counsel's performance during voir dire, claiming the defendant complaints are vague and believed by the record. Specifically, the government vouches for counsel's performance, arguing that trial counsel actively participated in voir dire. The fact that defense counsel participated in voir dire does not mean that his performance was objectively reasonable, where he agreed to the seating of multiple jurors who had seen Surviving R. Kelly, were aware of defendant's reputation that he loves little girls, and were familiar with his prior legal troubles, including his criminal prosecution for creating sexually explicit videos with a minor. Had there been even one juror who had seen Surviving R. Kelly seated on defendant's jury, his jury could not be deemed impartial. Incredibly, defendant's jury was comprised of two people, was comprised of two people, jurors 3 and 5, who watched Surviving R. Kelly, and numerous others who were fully aware of accusations against defendant for sexually abusing minors. Defendant contends that fully half of his jurors should have been disqualified for cause. Trial counsel did not move for any of them to be disqualified for cause and did not exercise any preemptory challenges against them. The government minimizes the extraordinary prejudice that defendant suffered when at least 2 seated jurors had watched Surviving R. Kelly. The government even claims that there was something strategic about trial counsel's decision to seat these jurors. The argument is nothing short of absurd. This court need only watch the embedded sample clips of Surviving R. Kelly to conclude that no possible trial strategy exists for failing to move to disqualify juror 3 and 5 for cause. The government's effort at constructing a trial strategy are unpersuasive. Surviving R. Kelly is a docuseries consisting of 11 episodes that graphically detail claims of sexual abuse against the defendant by numerous women. Some of the information communicated in the docuseries was presented at defendant's trial, but much of it was not. Indeed, the docuseries highlights the stories of scores of women who claim to have been victims of sexual abuse and offers no countervailing viewpoint. A large part of the documentary details defendant's prior criminal case that involved allegations of sexual abuse of a 14-year-old, which included allegations that he videotaped himself urinating on the 14-year-old. It is nothing short of mind-blowing that defense counsel acquiesced to the seating of jurors who came to the case with this highly prejudicial information that no human being could have put aside. Trial counsel's decision to seat these jurors is particularly troublesome where there was simply no reason to do so. Although the documentary was popular, it would not have been difficult to impanel a jury that did not include individuals who had seen the docuseries. Moreover, there is little doubt that this court would have granted defense counsel's motion for cause to disqualify any jurors who had seen the docuseries or were familiar with this prior criminal prosecution, probably with no objection from the government had defense counsel simply asked. Defendant contends that counsel's on-the-record performance is objectively unreasonable where no possible trial strategy exists for loading the jury up with people who were exposed to undeniably prejudicial bad act evidence, much of which would not have been admissible at trial. To the extent the government contends that the defendant himself agreeing to seating these jurors, it is dead wrong. As set forth in the attached declaration, defendant was provided no opportunity to review the juror questionnaires prior to trial and considered himself a bystander during this critical stage of trial. Defendant claims that he played no meaningful role in the jury selection process and that when he attempted to assert himself and express his concerns about jurors who had watched the docuseries, his concerns were dismissed. Indeed, defendant had no idea that at least 2 jurors who decided his guilt had watched the documentary. Defendant declares that he did not consent to the seating of jurors who saw Surviving R. Kelly or those who had knowledge about prior allegations of sexual abuse against him. The government argues that defendant cannot demonstrate prejudice because he cannot show that any juror had actual bias. The argument does not pass the laugh test. According to the government, actual bias is bias in fact. The existence of a state of mind that leads to an inference that the person will not act with entire impartiality. This record demonstrates that before stepping into the courtroom, 2 jurors heard over 360 minutes of victim testimonies, including graphic accounts of urinating on 14-year-olds. If this type of information does not lead to the inference that a person will not and cannot act with impartiality, it is difficult to imagine what would. A whopping 6 jurors were familiar with allegations that defendant had previously sexually abused minors and had faced legal consequences for such conduct. The government attempts to trivialize the prejudice to defendant, but it is simply beyond debate that defendant's jurors suffered from actual bias. Frankly, even if defendant cannot show actual bias, bias should be presumed here. The United States Supreme Court has observed a fair trial in a fair tribunal is a basic requirement of due process. Fairness, of course, requires an absence of actual bias in the trial of cases. But our system of law has always endeavored to prevent even the probability of unfairness. To perform its high function in the best way, justice must satisfy the appearance of justice. The requirement of due process of law in judicial procedures is not satisfied by the argument that men of the highest honor and the greatest self-sacrifice could carry it on without danger of injustice. Every procedure which would offer a possible temptation to the average man to forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the latter due process of law. Indeed, the United States Supreme Court has struck down convictions irrespective of a showing of actual bias where prejudice is inherent in those convictions. This is a case where prejudice is inherent in defendant's convictions because fully half of his jury was exposed to highly prejudicial and inadmissible evidence that invariably interfered with defendant's cherished constitutional safeguards. In the old but highly instructive case of Marshall versus United States, the United States Supreme Court reversed the defendant's drug conviction after concluding that exposure of some of the jurors to newspaper articles was so prejudicial to justify a new trial. During the defendant's trial, two newspaper articles got before a substantial number of jurors. The news accounts contained information that the defendant had two previous felony convictions and detailed the circumstances of prior arrests and convictions. Upon learning that the news accounts had reached the jurors, the trial judge questioned the jurors about whether they had seen the articles. 7 of the jurors had some exposure to the articles, but all assured the trial judge that they would not be influenced by the news articles and could decide the case on the evidence in the record. The trial judge denied the defendant's motion for a mistrial, finding that there was no prejudice to the defendant. The United States Supreme Court revised finding. We have here the exposure of jurors to information of a character which the trial judge ruled was so prejudicial it could not be directly offered as evidence. The prejudice to the defendant is almost certain to be as great when the evidence reaches the jury through news accounts as when it is part of the prosecution's evidence. It may indeed be greater, for it is then not tempered by protective procedures. Consistent with the teachings of Marshall, defendant Robert S. Kelly is entitled to a new trial. Half of his jurors were exposed to information of the character that was so prejudicial that it could not be offered into evidence. Indeed, had trial counsel simply moved to disqualify these jurors, it seems likely that those motions for cause would have been allowed. Prejudice to the defendant must be presumed given the inflammatory nature of the information that no average human could put aside. Defendant's convictions must be vacated and a new trial ordered. Defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant and the government star witness, Jane, that was imputed to her or to the entire defense team. Defense rests largely on his arguments, or as you were, defendant rests largely on his arguments contained in his opening memorandum of law. Defendant was denied his constitutional guarantee of conflict-free counsel when his attorney labored under a conflict of interest on her simultaneous representation of defendant and government witness Jane. Trial counsel further suffered from a Fulton conflict. Neither of these conflicts were waivable. In light of the foregoing, defendant's convictions must be vacated and a new trial ordered. Respectfully submitted, Jennifer Bongine. Bam, bam.
Bam, bam, bam.
Whew.
Bam, 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 bam.
Bam, bam, bam.
Okay.
We can rest on that one.
The first thing that got me is what everybody was reading, where Bongine said Getty's has made her case. She made her point with the case that she used to substantiate why Kells should not get a new trial. The case she cited backs up R. Kelly and them.
Wow.
Wow. All right, ladies, thank you. It is past midnight on
When is
this
the
side
judge
of the
supposed to
world.
respond, Sylvie, before you go? When is the judge supposed to respond? When are we supposed to hear something?
Well, she could respond anytime. It's no time, set time. So let's just keep aware. Just
All right.
I'll be on it. I'll be waiting.
Sylvia on the case. All right.
She got to really study this stuff and look into it, because my goodness, they were doing some stuff.
She probably already knows, just like the judge in Tasha K's trial. She knew. She had to know. Oh, they gonna come at me for this one. She had to know.
And because his attorneys didn't really hone in it like Jennifer in,
Mm-hmm.
she probably said,
Exactly.
"Well, I ain't gonna do your job for you." So
Right.
man, Jennifer brought it.
Yeah. She's on it.
But you know what the thing is, the judge you was in the courtroom helping them, so she felt their inexperiences.
Yeah.
Well, I
So,
think she thought too. She didn't know Bongine was coming down the pike. She didn't know Bongine was that ram in the bush. You heard? She didn't know that.
oh,
Mm-mm.
you know what? I wanted to play a video, that, but I'm gonna play it on my backup channel on tomorrow. Perspective. I can't play that video on this channel right here. I got to be very careful. So I'm gonna play it on my backup channel. Something that was shown. If you guys would want to go to my backup channel, I want to play that video over there.
Is it something against Robert?
No, it's just because it's somebody else's video.
Oh, okay.
And
Yeah.
this right here is too important for me to
Okay.
allow
Yeah. You
someone to try to knock it
Right,
down.
right,
right.
right,
I
right.
don't want it.
I
Yeah. I
understand.
want them
This is
problems.
definitely necessary. All right.
Okay.
So, guys, thank you so much again for reading. I
Absolutely.
appreciate you. And
Thanks, Prince.
guys, please share this live. Share it. All right.
All
You
right.
guys have a great night.
You
God
too.
bless
See
you
y'all
all.
later.
God bless you, Chad. God bless you, Miss Bell.
Yeah.
All
Yeah.
right.
This night.
All right.
Thank
See
you
y'all.
guys again. We'll just stay on the lookout for the judge's reply.
Okay.
Okay.
And also, we got another one. Nicole, not Nicole. Jennifer will be replying to the government's opposition for the trial, the sentences, the
Yeah.
sentencing being delayed. So
Right.
all right,
All
Okay.
right.
We on it. Infamous Sylvia on the
All
case.
right.
Her
all
and her
right.
team. All right. See y'all later.
See y'all.
Good night, everybody. Good
Bye,
night.
y'all.